Hi, I'm attorney Larissa Davis, and today I want to share information with you about what steps can be taken if a petitioner dies while a petition for their immigrant relative is pending or it's been approved and the adjustment of status has not yet fully been completed. So I'm going to talk to you first about eligibility based on who you are. So you might be a beneficiary or a derivative beneficiary. So first, let's get into what this relief is, where it comes from. This type of relief is discretionary, and so it falls under a part of the Immigration Nationality Act called Section 204L. And basic eligibility for Section 204L, relief for surviving relatives, means you may be eligible to seek relief if you are a principal or derivative beneficiary of a Form I-130 petition for alien relative. This is regardless of whether the petitioner was a U.S. citizen or a lawful permanent resident and that petitioner died. You could be a derivative beneficiary of that petition when the principal beneficiary dies. You could be a derivative beneficiary of Form I-140 immigrant petition for an alien worker, beneficiary of a pending I-730 refugee or asylee relative petition, and the petitioner died. This also applies for T or U non-immigrant visa holders, and a derivative classification and principal holder died, and also derivative beneficiaries of the VAWA classification and the VAWA self-petitioner died. This also includes the Form I-485 application to register for permanent residence or adjustment of status, and there's a battered spouse or child who filed, or a child under the Cuban Adjustment Act or the Haitian Refugee Immigrant Fairness Act, and the principal applicant dies. Another category, conditional permanent resident child of a conditional permanent resident filing a waiver of the joint filing requirement for Form I-751 petition to remove conditions on residence based on battery or extreme cruelty, and that person dies. So that's a whole lot of groups of people. You might know someone or be one of those people that fall under those categories, and I'll give you my contact information if you want to talk about your specific case, but I'll go ahead and go through what would make you eligible for relief under INA Section 204L. So an important part is that at least one beneficiary must have been residing in the United States at the time when that qualifying relative died, and that same beneficiary continues to reside in the United States at the time of seeking relief. The Department of Homeland Security might decline to actually give this relief if it determines in its discretion that doing so would not be in the public interest. So residence for the purpose of this section of eligibility means you reside in the United States. Your residence is in the United States, so you actually live here. So if you can show that your primary home when your relative died, where you actually were living, was in the United States at the time, and it still is in the United States, then you might be able to benefit from this section for relief. Certain petitions can have more than one beneficiary. So for example, the spouse or child or children of a principal beneficiary may be eligible to immigrate along with the principal beneficiary, as long as at least one of the beneficiaries was residing in the United States and they're still residing here. And then all of the beneficiaries can benefit from this section's relief. It also requires that someone must have resided here but not necessarily had a physical presence when the relative died. So for example, it's not interrupted by travel or events like a vacation, visiting family, travel for work. That doesn't affect eligibility for the Section 204L relief. Okay, it's not an entitlement. And basically, Congress gave the Department of Homeland Security discretion. So USCIS within the Department of Homeland Security has discretion to deny this relief under the section if they find it's not in the public interest. And what discretionary relief means is that they're basically weighing positive and negative factors against each other to make a decision in a case. And so in addition to meeting the basic requirements for this relief, your request must show that favorable exercise of discretion means that you have more pros that outweigh the cons in your case. And USCIS knows that this section is intended to help people who are put in an unfortunate position because this event happened beyond their control, and their intent behind it is to have more pros and to benefit people in this situation. So what about after the petition is actually approved? For example, after an I-130 is approved and you've got an I-45 application to register for permanent residence or adjust status, and that is pending. So if you're a beneficiary of that pending petition or application for adjustment of status when your relative died, USCIS may continue processing your petition or application if you request it and you're granted this 204L relief. So you've got to make a written request to USCIS to apply this section to your case. And so then if your petition was already approved, that approval is automatically revoked by function of the law under the Code of Federal Regulations. So this section 204L can still apply to a case that was revoked. The revocation doesn't mean that your case is over. Instead, revocation and reinstatement just provides this procedural mechanism that lets USCIS verify whether the section applies to your case, and if it does, they can decide whether to exercise discretion favorably. So when you request and you're granted 204L relief, USCIS would reinstate the approval of that petition that you had already had approved before the petitioner passed away and died. And so you can continue the process of obtaining lawful permanent residence or a green card. So when Section 204L relief is requested and granted, then you can continue the immigration process. Now, the processing times may vary, and it depends on where your file is located and other factors. There's no form or filing fee for this section of relief, and you've got to make a written request with supporting evidence of eligibility to send to a USCIS office. I know this was a lot of information, and if you think you're eligible, then you can, and you want to talk about it with an experienced attorney, you can give my office a call. We'll set up a consultation, go through everything as far as where you're at in the processing, whether your petition's already been approved or if it didn't get that far yet in the process, and you had a pending petition when the petitioner died. So contact me if you want to talk more about this. There's a lot of information on the USCIS website as well, but I know it's a lot, so it could be helpful to speak with an attorney about it. My office number is 601-724-9255, and I'm also putting my email in the description box below, and you can contact me. We'll set up a consultation and go from there.